So I know one of the things, moving on, one of the things that everyone's kind of freaking out about is this Google memo. And I'm not sure if you've heard about this Google memo, but there is a lot of spin on this. There is a memo that was circulating at Google. It was passed around at Google, and it ended up going internally viral. And then that memo ended up getting all over the web, and someone ended up getting fired for writing it. And that's what is going on. The writer, James Damore, 28 years old, was fired yesterday. You can view this memo at, someone has maintained, from what I understand, is the full memo at diversitymemo.com. Also, Gizmodo, I believe, published the full version as well. They just ripped out some of the images, unfortunately. But it's been hailed as an anti-diversity memo. It's been hailed as sexist, racist, misogynist, anti-women, anti-minority. It kind of sounds like those are the go-to attacks for anything people don't like. It gets all these labels every time. So it's important to actually dig in and see, okay, do these labels actually hold up? Now I'm going to talk about what's actually in the memo, and I'm going to go through it here later. But for now, I wanted to bring on Dan Eaton. And I'm going to bring him in now. Dan, you wrote a column. The column I read, it was in CNBC about the legality on can they actually fire this guy. You're with a San Diego law firm, Seltzer Kaplan McMahon Vidic, and you're also a professor at San Diego State University Fowler College of Business. Thanks for joining us on WHO in Des Moines today.
Happy to be with you, Justin.
So here's what I want to know. I would say legally, from a legal perspective, why don't you make the argument for why it is acceptable to fire James Damore, and then we'll go to make the legal argument for why it is not acceptable.
All right, Justin, when you say legal, you focused on exactly the right issue, because the issue is not whether it was right to fire Mr. Damore. It was whether there was a legal right to fire Mr. Damore. So when you're talking about whether Google had the right to fire him, let's look at a couple of things. First, Mr. Damore was an at-will employee, which means that Google had the right to fire him for any cause that did not offend fundamental public policy. The stated reason for firing Mr. Damore was that parts of his memo advanced harmful gender stereotypes. Well, that's allowed under the law. That's allowed under the law, even if the memo as a whole did not constitute the kind of pervasive sexual harassment or conduct that would give rise to an actionable claim for sexual harassment. The bottom line is that Google had a lot of discretion about whether to fire Mr. Damore, even though, and we'll get to this in a moment, some parts of the memo were indisputably protected speech.
Right, because it's obviously free speech is protected, but it looks like the way they're leaning based on their press release, and I'll be going into that a little bit later. Let's see. I don't know if I have it right at the top here, but basically it seems like they're going after the, he's perpetuating a negative work environment, or he's what would be the right word, pushing negative stereotypes or something like that. And if they go that angle, it seems like they have a little bit of a footing. But do they really have that angle out of that memo? Is there sufficient evidence to prove that?
Well, really, that's the question. First of all, the burden of proof is going to be on Mr. Damore, not Google, to prove that there was something unlawful about the termination. The question is going to be whether that was the real reason that was in the press release or in the email that the CEO sent internally to the employees that got out.
Well, that's a fair point, yeah.
Yeah, whether that was the real reason or whether it wasn't. The CEO of Google says that parts of that memo were absolutely protected. Mr. Damore had a right to say them, and they are subject to fair debate, such as his discussion about his feeling that conservatives in a predominantly liberal workplace were isolated. Well, under California law, you can't fire someone someone from deviating from the corporate's political line. That's a way to coerce political thought, and that's not allowed under California law. There's also an argument that Mr. Damore has that under the federal labor law, the National Labor Relations Act, that what he was doing was engaging in concerted activity to improve working conditions, specifically to eliminate certain kinds of diversity programs that he felt anyway discriminated against swaths of males and white males in particular. And that's the third reason that parts of the memo were protected. That is to say, he was complaining about what he viewed as the unlawful discrimination of some of these Google programs, these mentoring and promotional programs that favored or disfavored people depending on their gender or race. So that lays out the legal landscape as to the two sides that will be contesting if, and that's a big if, Mr. Damore ultimately challenges this termination legally.
Right. Now, I'm not a lawyer. That's why you're on. I think it's surprising that someone can fire someone and that's okay, and then the burden of proof lies on them. Wouldn't the burden of proof lie on the company doing the firing? Don't they have to say we fired him because and then actually show that?
It doesn't, and that's because of this concept of at-will employment, which is very well known. I mean, most people in this country are at-will employees unless they're in a union setting or they're high-level employees that are subject to a contract which prohibits firing except for good cause. The bottom line is that at-will employment means that an employer has broad discretion to fire someone as long as it doesn't offend like the discrimination laws or whistleblowing laws and so forth. And also, Justin, there's a widely held misconception that there's some sort of constitutional right to free speech in the private workplace. Well, there isn't. The Constitution applies to limits government's ability to abridge speech, not private employers. So let's get rid of that. That said, there are certain kinds of speech that are protected, and we've already gone through some of them. But the burden ultimately is going to be on Mr. Damore, not Google, to show that Google's firing, given the broad discretion it has, actually was motivated by an unlawful reason.
So, what if he went after, or what if he cited the discrimination part? Because, at will, from what I understand, Dan, at will employment laws don't supersede federal employment laws. The federal employment laws are still in play. We don't just throw them out. So what if he went after the discrimination thing? Because he says, hey, I'm a conservative, and they're discriminating against me because I'm conservative.
But Justin, as we discussed offline in the email exchange, that's quite right. The bottom line is, what was Google's true motive?
Right.
The fact is that he did say, Damore did have in this memo a lot of things that are protected. But the question is whether that is really why Google ultimately fired him. Establishing that link is going to be one of the hardest things for him to do. And you said that I posted one article on CNBC.com. I actually posted two,
yes,
as you know, which updated the earlier one, because the first one said there are broad parts of this memo that are protected, that he can't be fired for. But there are these other parts that Google is citing that says, no, for perpetuating harmful gender stereotypes
yes,
in violation of the code of conduct, he can be.
And now I read through this thing. And I don't know.
So did I twice.
Yeah. So. And I don't know. I mean, I can't say. One of my friends is like, so do you agree with the entire memo? I'm like, I can't possibly agree with the entire memo. I didn't write it, and I don't have any background for what he's talking about. I don't know if any of it's even real. I can't verify it. But in the memo itself, what about, perpetuating negative gender stereotypes? Could someone ask the question, why are these negative stereotypes even in place in Google's culture to begin with? And is Mr. Damore responsible for that?
Well, of course, it's difficult to unpack what you just said, but let me just focus on some of the statements he actually made in that memo, because I know you've read it. But he says, for example, that women generally are more prone to anxiety than men and have a lower risk tolerance, which makes them less suited for positions in tech leadership and positions as software engineers. Also says that women tend to be differently motivated, tend to be focused more on artistic and aesthetics than men. And that also explains their representation, their low number of representations in tech. And he always qualifies this by saying generally there are some women that are exceptions and so forth. But the bottom line is that, at least from Google's perspective, this perpetuated harmful gender stereotypes, and Google had the right, as it perceived it, whether they are right or not, about whether what he said was actually true, they had the right to fire him for saying those kinds of things in a way that Google felt, was harmful to the workplace.
Now, one of the questions I had is, I've seen this a lot, and I've read through it a few times, and it's a lot of stuff, so I could have missed something. Mm-hmm. But, and you just said it too. You said that he says that makes women less suited for this job. But I don't find, I mean, I'll have to read through it. Does he make it very specific that he calls out them as being less suited? Or does he say women and men are different? And could this explain why we don't have them in these positions, or why we're having difficulty? Does he actually call out women as being less suited?
I don't know if he actually says the word suited, but the point that you just made makes it clear that that's a synonym. That's to say, by saying that women and men are different in a way that makes them less prone to being appropriate for these positions, however you want to phrase it. The bottom line is he says there are reasons that have nothing to do with bias that explain why women and men are represented in different proportions in certain jobs in the Google workplace with regard to software engineers and tech leadership. And pushing women into these positions is to go against what comes naturally, biologically, temperamentally, and motivationally. And that's the kind of thing he says, and that's the kind of thing for which Google fired him.
And I think the question is he, because in the memo he makes it he's very careful to raise questions, and he doesn't make certain statements on who's qualified. But the question is he implying things, and is that where they're going to get him? Dan Eaton with the San Diego law firm Seltzer, Kaplan, McCann, and Vidic, and you're also the San Diego State University Fowler College of Business professor. Thank you very, very much for joining us on WHO Radio today.
Great talking to you, Justin. Thanks a lot.
It's a very interesting, and we're going to stay on this a little while because I also want to talk about the memo itself. And, we're going to go a little bit past legality and just talk about, did Google make the right decision in the court of public opinion? And we're going to dig through the memo a little bit and filter through spin and what it really says. I'm Justin Brady, in for Jeff Angelo on News Radio 1040 WHO.